Well, I hope you've all had a good lunch and are now ready to hear one of conservatism's most compelling, intellectually robust and successful speakers and politicians, a man who is a great friend of the Danube Institute as one of our distinguished fellows, a man who was the 28th Prime Minister of Australia, and if there is any justice in the world, will once again assume that office, a great friend of mine, Mr. Tony Abbott.
I must come to Budapest more often because only in Budapest and certainly not in Australia would I get an introduction as enthusiastic as that. Ladies and gentlemen, in simpler times, at least in the leading democracies, it was government that ran the country, the parliament that made the laws, and the courts that decided what was illegal. And yes, in Westminster systems, the executive was formed in the legislature and generally controlled it, and the executive has normally nominated judges and often determined whether they're appointed. But because each arm of governance generally respected the prerogatives of the other, the system more or less worked, governments got things done, legislators cooperated with each other across the aisle, the civil service was responsive to the government of the day, and courts didn't try to second-guess governmental decisions. But that's not how it is now. Election results aren't respected, as in the America of Biden and Trump. There's revolving door prime ministerships in Britain and Australia. It's unelected officials that often seem to be in charge, sometimes because voters prefer it that way, as in the pandemic, and sometimes because the administrative state seems impervious to democratic direction, as in the botched implementation of Brexit. And in particular, prosecutors and courts often seem to be the agents of injustice rather than justice. Things fall apart. The centre cannot hold, mere anarchy is loosed upon the world, or so it seems. For liberal democracy to work, as John Howard often said, the things that unite us should always be bigger than anything that divides us. Now, these aren't the first times the social fabric has been under strain. Economic deprivation during the Great Depression and lingering institutional racism and opposition to government policy in the 60s sometimes brought cities and even countries to the brink of civil disorder. But these times do feel different and more dangerous than anything since the 1930s. In the face of deep challenges, from a militarist dictatorship in Moscow, an Islamist dictatorship in Tehran and a communist dictatorship in Beijing, the Western democracies are feeble and divided, having militarily, industrially and even culturally disarmed in the years since their seeming triumph in the Cold War against the old Soviet Union. This is clearly a civilisational moment, because others don't believe in us as they were supposed to after the end of history, and we no longer quite believe in ourselves, despite all the objective evidence of the Western achievement. One of the reasons why Russia is now slowly grinding down gallant Ukraine is because Ukraine's friends have helped it enough to avoid defeat, but not enough actually to win. Partly from fear of what a humiliated, nuclear-armed tyrant might do, partly through internal division over the extent to which other people's well-being is our business too, and partly through resistance to the industrial mobilisation needed to match an economically declining but geopolitically driven dictatorship. After initially being the largest non-NATO contributor to Ukraine's defence, primarily through the delivery of some 100 Bushmaster armoured vehicles and by helping to train in Britain the Ukrainian infantry, Australian support for embattled Ukraine has now almost dried up, with even a recent request for coal refused, presumably because that might add to the temperature in Kiev. Likewise, one of the reasons why Israel is bogged down in Gaza, hesitant to destroy the Hamas leadership, is because its friends can't quite grasp the moral distinction between a liberal democracy prosecuting a just war against a terrorist statelet pledged to its destruction and an apocalyptic death cult that uses civilians as human shields. Somehow, civilian deaths in Gaza are not the fault of the terrorists who put command centres and military stores underneath schools and hospitals, but of the Israeli Defence Force, even though the IDF has actually been far more fastidious about avoiding civilian deaths than Bomber Command ever was. And in a further indignity, global institutions invoking a bogus morality have bid to arrest both Israel and Hamas's leaders for war crimes and to restrain the actions of Israel, but not Hamas. This is the moral confusion arising from the left's long march through the institutions, with a generation of students conditioned to see issues in terms of oppressors and oppressed, with Israel damned as a settler state with white privilege, and thanks to a generation of permissive immigration, there's now Islamist subcultures within Western countries for whom sectarian solidarity is what matters most. It's this growing conviction of the democracy's decadence that's emboldening Beijing in its intimidation of practically independent Taiwan. Beijing doubts the will to resist, partly because of the economic cost of decoupling from China, partly because US commanders now doubt their ability to win an air-sea battle in the Taiwan Straits, and partly because societies that have had it so good for so long are simply unprepared for a potentially existential struggle, even on behalf of a country like Taiwan that testifies to the universal appeal of the Western way of life. It's telling that for the first time since the ANZUS Treaty in 1951, Australia has just refused an American request for military help, declining to send a freedom of navigation frigate to the Red Sea. Our government is using its commitment to AUKUS submarines a decade hence to mask cuts now to our fighting capacity. And rather than admit to an instinctive pacifism, it would prefer to tell our allies that we'd like to help, but lack the means to do so. This general decline of the West is the dispiriting background to any discussion of the way particular institutions like the courts have been corrupted, and a safeguard against the capricious exercise of power like the rule of law degraded into the rule of lawyers. People have never had more access to information, yet rarely been so ignorant. Never been more materially rich, yet rarely more culturally and spiritually bereft. And whatever might distinguish today's leaders in business, the academe, the law, the military and the church, no less than in politics, it's rarely character, courage or conviction. Historically, at least in the Anglosphere, our most iconic institutions have worked for the protection of society against the state and for the freedom of the individual against oppression. Be you ever so high, the law is above you, insisted the jurists and the parliamentarians against the Stuart kings. No taxation without representation, insisted the American colonists against the British government. From centuries of trial and error, the king was under the parliament was under the people were under the law, and the law was under God, or at least some concept of the common good. At its zenith, there was an expectation of humility. Even for exalted people and institutions, our pride was supposed to vest in the things beyond ourselves, an attitude most wonderfully conveyed in the statement of our late Queen on her 21st birthday that my whole life, be it long or short, shall be devoted to your service and that of the great imperial family to which we all belong. Our general malaise is not confined to the use of the law as a sword, not a shield, but that's a key measure of it. The EU is invoking the rule of law quotes to coerce member governments whose policies it dislikes, as we've heard today. But this is not law as usually understood. that's hallowed by parliaments and custom. Rather, it's a form of administrative bullying. Then there's the judicial and institutional harassment of President Donald Trump, from the US security chief's public insistence that the Hunter Biden laptop story was Russian disinformation, to the abuse of judicial process on charges that are trivial, exaggerated, or in the case of removing classified documents, could as readily be laid against his opponent. But rather than the final nail in his political coffin, their effect has been to galvanise his supporters and make his opponents look like they can't beat him fair and square in debate and at the ballot box. They've actually helped to turn a very flawed candidate into an object of sympathy while further eroding respect for institutions. A rather more sinister abuse of process against a far more worthy character has taken place in my own country. Cardinal George Pell was the first Catholic bishop to take decisive action against the plague of clerical sexual abuse, sacking wayward priests and reporting them to police rather than moving them to another parish and hoping that they'd see the error of their ways. He set up the first formal mechanism to compensate victims without the need to go to court. And while himself a pastoral priest, he was also an entirely orthodox churchman who occasionally questioned modern pieties like the climate cult. In the absence of any specific evidence against him, Victoria Police set up a formal investigation into the Cardinal and even advertised for complainants. Eventually, a charge was brought without credible evidence. A conviction was finally secured after a hung jury at the first trial, and an initial appeal failed before the High Court unanimously dismissed the charges against an innocent man who'd been made a judicial scapegoat for the crimes of others. In the words of a Pell critic, the eminent Jesuit, Father Frank Brennan, quote, "The case against Pell was nothing more than an appalling police sting operation, protracted by grossly erroneous judicial reasoning by Victoria's two most senior judges. Thankfully," says Brennan, "his prison journals revealed a Christian grace in the midst of adversity and profound injustice." Now, it's worth noting that both the senior police officers in charge of the Pell prosecution subsequently became police commissioners, and the two senior Victorian judges remained in their posts despite their professional humiliation by their senior peers. But Pell's is just the most serious case of religious persecution. The Tasmanian human rights watchdog began legal action against the Archbishop of Hobart for a pamphlet defending marriage as between a man and a woman. Taxpayer-subsidised trans activists complaining under anti-discrimination law have bogged down a former head of the Australian Christian lobby in 2 years of expensive legal jousting. And even though the rights bureaucracy is plainly more concerned about the rights of some than others, there's been no real attempt to rein it in. Indeed, my government's brief attempt to make anti-discrimination law less injurious to free speech was grounds for party room unrest, either for going too far or not far enough, as this is yet another issue on which the conservative side of politics divides into more conservative and more progressive camps. And as well as persecuting those who offend against the canons of political correctness, in my country, the law is also now used to frustrate the decisions of government in favour of green fanatics who won't take no for an answer. The Adani coal mine in Queensland was held up for a decade by environmental and native title court challenges that ultimately failed to stop it, but that drastically reduced its scope as the overseas investors spent billions before any return. Under Australian administrative law, courts can review ministerial decisions if the decision maker has failed to, quote, take into account a relevant consideration. And under environmental law, green groups can bring court actions without having a direct interest in the case. A Northern Territory offshore gas development that had passed the most stringent environmental tests was recently blocked by a sudden claim that it would interfere with the crocodile dreaming. that had been attested to by a senior university anthropologist, even though Australian Aboriginals had never been a maritime people. Eventually, the judge scathingly dismissed the objection as tantamount to academic fraud, but not before the proponent had lost a reported $800 million. An even bigger gas field off the coast of Western Australia faced a last-minute hold-up because of an alleged failure to consult with one Aboriginal person, even though all the official Indigenous representatives had been consulted. Both these cases were brought with the support of the Environmental Defenders Office, an activist legal NGO that the current government has just funded to the tune of $10 million a year. Hence, taxpayers are funding, you see, Australia's not quite the nirvana that you think it is. Hence, taxpayers are funding court cases that will make their own burdens heavier because they end up stymieing the fossil fuel developments that would add to employment and revenue. And the government is funding an entity that works to frustrate the decisions of government. The government, indeed, wants to have it both ways, to say that it's in favour of development to one audience, while to another, funding the entities that frustrate development, and in the end, it's the whole polity that's discredited as performative rather than effective. What's happened over recent decades is a tendency for unelected and unaccountable judges to insert themselves into political decision-making on the assumption that their decisions are untainted by politics and thus superior to those of elected and accountable ministers. Activists with a monomaniacal objection to fossil fuels are using the law to win through the courts what they could never win through the political process. They're exploiting the judiciary's own leftist mindset after a couple of decades of judicial appointments, mostly by Green left Labor governments. Because the process is the penalty, the best remedy to all this would be a government that changed the law to ensure that endless legal nitpicking can't stop a project that has met all reasonable objections. But whether it's changing the law to prevent people without a specific interest bringing an action, or whether it's just routine reiteration that the world needs our resources, so we have a duty to make them available while they're wanted, successive governments have been reluctant to alter the status quo. The stumbling block has been this perception that legal processes are sacrosanct and that environmental protection is a higher cause, even though some legal processes, like those utilising the European Convention on Human Rights to stymie British border protection, as if European jurisprudence is superior to British justice, are plainly meant more to thwart the elected government than to protect anyone who's actually being oppressed. And even though environmental protection and the rights of foreigners should be balanced against economic advancement and the rights of citizens, if respect for law and legal process is to be maintained. This abuse of the law to make political points is just another example of the myriad problems that arise when too many people are ignorant of their own story, fail to understand how their culture has evolved, and can't grasp how society is a trust between those who are dead, those who are living, and those who are yet to be born. It's actually an abundance of respect for all cultures other than our own that's now the mark of most Western countries. In Australia, for instance, there's now no prime ministerial press conference that does not take place in front of 3 flags: the national flag, plus the Aboriginal flag and the Torres Strait Islander flag. Institutions that wouldn't dream of toasting the king at a formal dinner or beginning any official proceedings with a prayer now routinely begin their activities with an acknowledgement of the traditional Indigenous owners, as if that's the only cultural inheritance that matters. And even though Christianity, or the coming of the light, is almost certainly more important to more Indigenous people than ancestor worship. So until we've elected leaders brave enough to drop the pieties that imply that our country belongs to some of us more than to all of us, and to stop flying the flags of some of us, co-equally with the flag of all of us, there's really no hope of reversing the cultural decay that's behind the abuse of legal process and much else. Are we collectively capable of recovering the historical memories and our cultural self-confidence to face this civilisational challenge? Sterner times could soon force us to rediscover our better selves.
Well, thank you, Mr. Abbott, for that wonderful speech, which I hope you will publish so that we can all read it and digest it fully. Our penultimate panel of today is on the rule of law against constitutional sovereignty, so follows very nicely from that. It's my great pleasure to have as the moderator of this a colleague and friend, Professor Frank Füredi, who leads the MCC in Brussels. From the Comillas Pontifical University of Madrid, Professor Miguel Ayuso. Nikola Kedhi, the chairman of the board of directors of the Albanian Policy Centre. And Nikola Bauer, a senior research fellow at the European Centre for Law and Justice.
I would like to answer Tony by saying that we do have the courage and we do have the capacity to reverse this, but only if we take ourselves a little bit more seriously, not always use the language of our opponents, not just simply react to their latest scandal, but we ourselves have got to initiate. We ourselves have got to start this fight. It's important to have this conference, although I think it's a big mistake to have a conference on the rule of law when it should be ruled by law, which is what we're talking about. Because what has happened is that the rule of law has been perverted to the point at which it bears no relationship to any of the legal principles that legal scholars would historically recognize. It's become an entirely detached kind of concept. And we ourselves need to point that out. We ourselves have got to, for example, explain that constitutional sovereignty actually trumps the rule of law, because the rule of law is not independent of constitutional sovereignty, but ultimately derives from that. That is the foundation. And the rule of law, unless it's based upon a pre-existing, logically prior foundation, becomes merely rules. And that is really what we're talking about in the European context. What they do in Brussels is not make laws, but make rules. And they make rules time and time again in a way that it proliferates and acquires a dynamic of its own. I want to suggest that there are 3 or 4 important themes for our panel to kind of consider. I think, first of all, it's really important to understand that the law, and I experience this in Brussels every single day, the law has become an instrument of anti-majoritarian decision-making. When you talk to Brussels lawyers and you have a drink with them, as I'm forced to do from time to time, they're not the kind of guys you want to hang out with, but my job makes me do that. When you talk to these people, they really, really hate democracy. Their ethos is fundamentally anti-democratic, and they regard people as these morally inferior beings that do not really understand what is in their best interest. That's how they think. That's their imagination. And therefore, from their point of view, their objective is to prevent policy and ideals and a way of life being influenced and determined by the majority of society. It seems to me that the judicial activism that we now see throughout Europe, thanks to the American example, it's almost like California values now become institutionalized in Brussels, and they do sound like as if they're from Los Angeles or some place like that. You find increasingly that what they are really in the business of doing in promoting constitutional courts, in promoting judicial reviews, in promoting the European Courts of Human Rights, all these things, is they are trying to insulate the political system from popular pressure. That's the key accomplishment of the rule of law discourse. It's basically a way of creating this insulation so that political decisions, real political decisions, are masquerading as if they are legal innovations rather than what they really are. And secondly, we might want to consider the fact that so-called transnational legal theory, which as a sociologist I find really bizarre, because these days, whenever I hear the word trans, you know we're in trouble. You know we're in deep trouble when you hear that. But when you hear transnational legal theory, and there are professors of transnational legal theory, what they are really talking about is to extend judicial activism beyond the boundaries of the nation state, so that no sovereign power, no sovereign institution can actually hold them to account. I mean, one of the reasons why our cosmopolitan elites love transnational sort of legal theory and legal instruments is because there's no way that you and I or any political party or any democratic decision-making forum can somehow influence the decisions that they arrived at. I think that if you want to know what a transnational legal theory looks like and what its accomplishment is, look at the European Court of Human Rights. Now, the European Court of Human Rights is very interesting because they get to invent 2 or 3 new human rights every month. It's almost as if, the old system where in 1940s you had 4, 5, 6 human rights suddenly multiplies and mushrooms and expand. And what they're doing with the European Court of Human Rights is that they ensure that fundamental questions touching on moral norms are taken out of the realm of policymaking. So basically what the European Court of Human Rights has done is they've usurped the domain of morality. They function as if they are moral gods, as if somehow they are the conduit through which divinely decided principles can be communicated. And they basically can decide whether a policy passed by Parliament in Britain or in Paris or in Berlin meets their standards of human rights. Very powerful position because of the way in which morality itself has become entirely colonized by them. And finally, I think that the EU-style lawmaking process does something that we very rarely talk about. It actually depoliticizes public life. Because if you have the juridification of everyday life, and if lawmaking acquires this incredible momentum, then the lawmakers and their whole industry become far, far more important than elected politicians. And the depoliticization of so many decisions is now incredible because they tell us the experts have decided, the court has decided. It's almost as if science has spoken. So many things have been spoken and decided and have been taken out of democratic policy debates that it gets to the point where we poor old Democrats in party politics can basically kind of make decisions as to whether the place where I live in England, in Canterbury, can have streetlights that work on Sundays as well or not. So little kind of tiny kind of principles become important. Finally, I think that one of the things that I'm really concerned about, other than the arbitrary use of political power to undermine sovereignty, and in particular national sovereignty, is this. The rule of law, in its conventional sense, was partially developed in order to limit the arbitrary use of power. But what happens if the arbitrary use of political power is now mediated through the rule of law? What happens if the law becomes the medium through which arbitrariness becomes generalized and normalized in our society? How do we react and respond to something like that? And something like judicial review can just simply negate decisions that the majority of society really wants. And finally, I'd like to introduce something that I think, I'm not a lawyer, you guys are the lawyers, that we should be talking a little bit more about, which is this: who makes the rules? Right? Who are these lawyers and who are these judges? Now, the one thing I do know a lot about is that in a place like Britain, in all the legal universities, all the schools, where legal scholarship is taught, the dominant ethos that young people learn when they go to law school is what's called critical legal theory. Now, critical legal theory, combines the worst features of intersectionality. It makes Black Lives Matter looks like a positively moderate force. It kind of immediately internalizes all the latest principles of identity politics. And the people that make the rules are the products of that. But that's not the worst. That's not the worst. One thing that's even worse is that when you make a law or a rule in Brussels, the way you do it is this. You call up, you take out your phone directory, right, and you see, who are your mates, which NGOs they work in, and you set up a stakeholder meeting. These stakeholder meetings are not eating steaks, nothing like that. The stakeholders are individuals who are meant to be independent and neutral, but they're actually their best buddies. So the NGOs come along, they already know what's expected of them, they already know what needs to be said. They kind of come to a consensus. I mean, every time you hear the word consensus now, it's a bit like the scientific consensus on global warming. You know exactly what to expect. And then on the basis of the consensus that they've drafted, a law is enacted. So the point I'm really making is that we need to be a bit more critical and questioning, and actually call into question the legitimacy, the actual legitimacy of the laws that are being passed, the rules that are being passed, and the way that the rule of law is fashioned. And I think, we in Hungary can set an example. We're not the only ones, because fortunately in Spain and in Italy and France, Holland, everywhere, people are beginning to kick up against this. And we got to basically mobilize and call into question this discourse. And our task is to evolve an alternative legal language that's based upon the principles of Western moral norms that directly goes to battle and questions what they're about. Thank you. So we have a great panel, probably the best panel you'll have the next 2 days. And basically, I'm going to get them to give their views on what they think is really believed. I want to know what you're passionate about and what you think is really, really important. And we'll begin with you, Miguel.
Thank you. I'm going to try to answer all the questions our president has offered in the initial words. And if I wanted to be provocative, I could say that I'm as opposed to constitutional sovereignty as I am to rule of law. Naturally, I have to explain this sentence so provocative I have made, and that requires a certain amount of nuances. You know that the medieval philosophers used a sentence, very interesting, initium doctrinae sit consideratio nominis. So the beginning of the study, the beginning of the wisdom finally, implicates and starts with the explanation of the terms. So explicatio terminorum. And I'm going to take seriously words, not only rights, but also words, as it has been told this morning in several panelists, and say one thing about rule of law, constitution, and sovereignty. And explaining this, I hope I'm going to give an initial response to the questions that our president has made us. Let's start with rule of law. rule of law has two perfect, distinct meanings. We are using rule of law in a univocal sense, and I am not sure that's correct. It seems to be that we have to distinguish between the meaning of rule of law, the strict rule of law, in the Anglo-Saxon world, mainly in Britain and after in the United States, and rule of law in the continental European world. Because as this conference is in English, we have to use rule of law. But perhaps it could be better not to use only rule of law, but to distinguish two different meanings. For instance, when we talk of rule of law, in general, in the Anglo-Saxon world, we think about something like a heritage. Something like, as in French say, acquis, l'acquis, something received. On the contrary, in the continental world, mainly in France at the beginning, but as always, made by Germans finally, because the French invent things, and the Germans carries these things to perfection. Perfection could be in a good way or in a worse way, in a bad way. We talk about Rechtsstaat. Rechtsstaat is translated in the Latin languages as État de droit, Stato di diritto, Estado de derecho, Estado de direito. In all these languages, the meaning is not something received, it is not a heritage, but mainly an auto-limitation of power. And it is not the same thing that power is contained in traditional heritage than saying that power is contained by limitation established by the power. So this would be the first remark. If we go on to constitution, we could discuss a lot of things, but because if we want to talk about constitution seriously, we can think that constitution, it is a very deep reality. Americans tend to consider constitution in such a way, but certainly we Europeans do not think of constitution in such terms. Because constitution for us, it is something who changes a lot. We have had so many constitutions. I could give you the list of a Spanish constitution, but our friend from France could do the same thing. And constitution is an ideological concept. An ideological concept. We have to remember the Article 16 of the Declaration of the Rights of Man and Citizen. So 1789. So separation of powers and guarantee of individual rights. But separation of powers is a myth. It has been always a myth. But today it's even more clear that it's a myth. And individual rights, what are and which are individual rights? Finally, individual rights are those who the constitutions and the international declarations consider. So nothing outside the positive law. But today, constitution does not exist anymore because we have constitutional courts. and constitutional courts have displaced the law, and particularly the Constitution. And we can find a lot of people who talk against Constitution and in favor of post-Constitution. These are postmoderns, we could say. But at the same time, there are so many people who, moderns, consider that the activism of the judiciary has destroyed Constitution. So they are defending Constitution, but Constitution has two different and opposed meanings. Finally, sovereignty. When we talk about sovereignty, sovereignty is it's a technical concept also. Sovereignty has been invented by a Frenchman in the 16th century, Jean Baudin. Who is the sovereign? The sovereign is the one who depends only on his sword. So it is the naked power. It is the power not qualified by its finality, but the power qualified only by the use of the power, so not qualified. So sovereignty of the prince, sovereignty, national sovereignty, popular sovereignty, state sovereignty, individual sovereignty are the same thing in the sense that there is only will. So I would not say that we have fight against rule of law, a rule of law who becomes a tool for political war, but also we have to be attentive to defend sovereignty. We have to defend, in my opinion, other things. But as a provocation, it seems to me that it is enough for the first words. Thank you.
Thank you very much. That definitely was a provocation, and I'm definitely provoked. But I'll keep my words to myself. I'll go to Nikola, if you could speak.
Thank you. Well, I wanted to start with these two concepts. We have transnational rule on one hand, and how consistent or even opposite that is with constitutional sovereignty. If transnational rule means an imposition of norms, rules, regulations, directives from outside a certain country by an unelected maybe body, then that, of course, is the exact opposite of constitutional sovereignty. We should bear in mind that constitutional sovereignty in itself is not absolute. It is quite limited. And it is used to define and to limit certain rights. Constitution and sovereignty are well defined, written, and upheld in tradition. On the other hand, transnational rule is an international cabal that is hard to be defined. It tries to avoid to being defined. In my perception, constitutional sovereignty is what we have built, what we know, and what we need to preserve. Transnational rule means what we don't know. And from those that we have not elected, and that it means that we cannot hold them accountable. Former US Supreme Court Judge Antonin Scalia would say that the Constitution is not a living document. It is 100% dead. And that means that it cannot evolve or change based on changing circumstances. Whereas if a constitution is real, it is because it is an enduring constitution, not a changing constitution. That's what Judge Scalia meant when he said the constitution is dead. There is no country in Europe, I think, that best exemplifies the difference between transnational rule and constitutional sovereignty than Albania. What has occurred in Albania for the past decade is an imposition of certain rules, regulations, laws by outside bodies, unaccountable bodies, that have given the power in Albania to one man, to one party, and that is done in the name of democracy. Due to its past, due to its communist past, and also to a chaotic transition, Albanians don't have much faith in their own institutions. So they have a lot of faith in the EU, in the US, believing that since they have created over the course of the past centuries, liberal democracies, constitutional countries with strong institutions, they would do the same in good faith in Albania and accept Albania as one of their own in the European Union. However, during the past several years, the Socialist Party, with the help of bureaucrats from the European Union, from the US, have implemented a judicial reform with the help of the Open Society Network as well, with the use of taxpayer money. So I guess all of you have paid for our judicial reform. Thank you. And removing or making what was a sort of bad situation, sometimes bad, sometimes good, with sometimes some corrupt judges, other times a little bit more effective, into a system that is dependent on only one man, the Prime Minister. And the funny thing is that, so this, of course, now the judicial system doesn't work at all. There are tens of thousands of cases in backlog, and the basic individual liberties are not respected. The funny thing is that we get European officials, US officials all the time saying how perfect this judicial reform is. And it's so perfect that they chose not to implement it anywhere else. There was a discussion a few years ago in North Macedonia to do something like that when the left-wing government there came into power. But they chose not to because it was so perfect that it didn't work in Albania. And we have now the leader of the opposition, Berisha, who is under house arrest. And there is no accusation against him, no single accusation against him. He's been under investigation for 4 years, and either he's very good at hiding whatever he's done, or he hasn't done anything at all. But a member of parliament and the leader of the opposition is currently being held down under house arrest. In dictatorships, in authoritarian countries, at least they make up some sort of accusation. But in Albania, apparently, there's no need at all. There was a case a couple of years ago when Mr. Berisha returned into active politics, and the base removed the previous chairman, who was happy with the judicial reform. He also happened to have good relations with the Open Society Foundation. And Mr. Berisha was elected by the base of the party as the new chairman. He's also the historic leader of the right in Albania. But the government didn't recognize this. The courts, after this judicial reform, didn't recognize him as the leader after a democratic process had taken place in a political party. So now, for 2 years, this matter is going from one court to another, who passed this issue among each other. And last year we had the local elections, for example. They didn't allow his name to be on the ballot paper as the leader of the Democratic Party. The party and the coalition were saying, our leader is Sali Berisha. The government was saying, no, he's not your leader. So they had to change the name against the will of the opposition coalition. Next year, again, we have the general elections. And if nothing happens, the same situation will repeat itself. So we are seeing in Albania this imposition of rules from outside that have destroyed a country that was in a transition period, of course, with all of its imperfections, with corruption as well. But now we have a judicial system that for the bureaucrats, maybe it's a nice system. For them, maybe it works, but they come and visit for 2 hours and leave. Whereas for the ordinary citizens, it doesn't. And it has managed to create this semi-authoritarian country hiding under a liberal democracy facade that is infringing on human liberties. Imagine when it can happen to the leader of the opposition, who's been in politics for 30 years, what can happen to an individual citizen. So this is not only a theoretical question, what you posed between transnational rule and constitutional sovereignty, but it's actually happening, and all of Europe is turning a blind eye to this. Even conservative parties are turning a blind eye to this, because many have their own interests in the country, in the Balkans. Many are influenced, many fall prey to lobbying, and it's very alluring, of course, but a whole country is being destroyed. And the main issues or the main countries that draw a lot of attention are what's going on in Georgia, for example, Ukraine, what's happening in Israel, and all of these major issues. But in the Balkans, we may soon have quite a lot of problems, because even in the most pro-Western country, Western bureaucrats, unaccountable, unelected, are helping destroy a country and sacrificing the democracy of a country for the sake of stability. But a country that doesn't have democracy does not have stability in the long term. Thank you.
I mean, you made some very powerful points, and we have to think about a world where people living outside of Albania have got more power over the future of Albania than Albanians do, which is why I think the question of sovereignty is probably the single most important challenge that faces us. How do we give meaning to that? Particularly when lawmaking, has acquired this promiscuous form kind of globally. I mean, just think in the last week or so, the ICC, the International, whatever it's called, Criminal Court, and its decision about Israel, I think it's quite interesting in that respect, the way that they could almost basically signal that Israel now is somehow, it's okay to demonize Israel because it's this kind of a state. So over to you from France.
Thank you, Professor. Thank you very much to the three organizers of this great conference. After Albania, I would like to do another case study. I will focus on the European Court of Human Rights, and I think this focus will help us to answer to the questions Professor Füredi introduced. So as you know, the European Convention of Human Rights was signed in 1950, and today 46 states are party of this convention, and this convention created the European Court of Human Rights. I would like to bring up several issues raised by this European system of protection of human rights. First, starting by the convention itself, some issues that were present from the beginning. Then I will show that the court made many abuses from this system, and at the end I would like to bring some solutions governments could use to limit these abuses of the court. So first, from the beginning of this system, some criticism can be made on the text of the European Convention on Human Rights itself, from a law perspective. So the first problem is the lack of definition of words, of notions. So we talked about it a lot today. The European Convention of Human Rights protects human rights, but there is no definition of what a human is. When does it start, for example? So it raises a lot of problems. Human rights since 1948 are based on dignity, but there is no definition of dignity either. And it protects rights such as the right to freedom of religion, with no definition of religion. So each time a person invokes rights before the court, it is the court itself which has the power to decide. So these are the problems in the text itself. And then, so as you said that Brussels lawyers hate democracy, sometimes we can have the impression that Strasbourg lawyers hate even law, because we will see some abuses of this court. So first abuse, in 1978, the court unilaterally decided how it will interpret this convention. And it chose not to interpret it as a dead convention, as a dead constitution, but as, I quote, a living instrument to be interpreted in the light of present-day conditions. This approach is called by the court dynamic and evolutive, and it is based mostly on another notion, European consensus. And by this interpretation of the law, the court completely changed the meaning of the convention. For example, you have the right to marry for a man and a woman, and it decided since 2010 that it was no longer to be limited to a man and a woman. The text says a man and a woman, but the interpretation says it can be other. And in 2022, the court applied the principle, I quote, "No one shall be deprived of his life intentionally." It's a very clear principle. It applies this principle to Belgium and said that it was compatible with euthanasia. So it's two examples of how judges can create from scratch, can create law and rights. And this goes against the principles of legal certainty and predictability of law. A second abuses in 2005 of this court, it unilaterally decided that it could dictate to states binding provisional measures. These provisional measures, before the judgment on the merits, were considered before by states and by the court as part of a kind of cooperation between the court and the states. The states refused many times since the convention to make them binding, and the court recognized many times that it was not binding. But one day the courts condemned a state, Turkey, for having ignored provisional measures. So it considers, for the first time in 2005, and still considers today, that ignoring these measures is a violation of European Convention. And today, because of this choice, which is unilateral and which goes against the states, the courts suspend many expulsion of illegal immigrants. We had many examples in the recent years. So it's not in the treaties, but it's a power grab from the courts to make these measures binding. And third and last abuse that I would like to talk about, it's the problem of conflicts of interest affecting some court judges. So Nikola talked about Albania, the reform of the justice system, and this is one example because one judge, the Albanian judge of the court, before being judge, he fought this reform with the Open Society. He built this reform, and then when he was a judge at the European Court of Human Rights, he made a judgment on the reform to say that it was good. So it's the same person who created the reform and who is part of the panel of judges who validated the reform. So this is a conflict of interest, and there are many others because the legal creativity of this court encouraged many NGOs to lodge application with a political purpose in order to change the law. And since some judges are not professional magistrates but were former director of NGOs or member of NGOs, you had in the last 10 years 200 situations in which one judge was judging a case introduced by his former NGO. So in a clear situation of conflict of interest. So we talked a lot about the relationship between rule of law and politics. And these abuses show that even the rule of law itself sometimes goes clearly against law. So what can we do with all this? So maybe the discussion after will help us to see. But I would just like to recall that leaving this European system of protection of human rights has no financial consequences. It's not directly related to the European Union. So governments could think about this. And then there are many other solutions that government explore. Hungary decided not to apply some controversial judgments, some judgments which go against the text of the treaty it signed. And some other states really succeed in advancing some reforms. So there is also this possibility of reforming from the interior. Thank you.
Yes, thank you very much. I think the points you raised about the European Courts of Human Rights are really quite important because outwardly it's got this sacrosanct moral authority, but inwardly it's an entirely corrupted institution that relies upon the political ambitions of people that finance the non-governmental organizations that are part of its circle. And certainly in Britain, a lot of people are demanding that Britain leaves the European Court of Human Rights, even in Parliament, because of the fact that despite Brexit, we're still blessed with this institution that never ceases to sort of stop its way. I'd like to go back to the question that Miguel raised first of all, on the question of sovereignty and constitution. Perhaps we can reflect on sovereignty, because unless I misunderstood you, you said that sovereignty was a technical accomplishment. And maybe because I'm ignorant of the law, I tend to think that sovereignty isn't just simply a legal principle, but is also a philosophical and a principle that in a sense derives from political theory. You mentioned Baudin elsewhere, but I think that we have to look at the context today. And the context today is such where the same people that celebrate the rule of law and think it's the best thing since the Ten Commandments are also the same people that criticize sovereignty. And certainly in the English language, whenever the word sovereignty is used, they always say the myth of sovereignty. So that, in a sense, sovereignty is devalued as this impossibility. Whereas it seems to me that for the people of Europe, sovereignty is one of the few protections they have, whereby they know that within a certain certain national framework, that they consider a community, and that community is able to make decisions about matters that affect their lives, which is really crucially important and is now being negated by the academia. So I'd just like to have perhaps you and come back on this and see how you see this.
Oh, I understand perfectly your point, and I have reached my objective with your remark, because I wanted to criticize from an abstract point of view the separation between rule of law as a tool for the evil and sovereignty as a tool for the goodness. I wanted only to explain that in reality there is a connection between both of them in a good or in a bad sense. But in practical terms, I can understand perfectly that today who uses rule of law as a political and strategical tool against good causes, in general, are against sovereignty, as sovereignty was the evil. But in reality, that means that today sovereignty has passed from national level to global level. So we are in front of a globalist sovereignty. And in such a sense, I wanted to provocatively make the point. But I must agree with you that in practical current terms today, we can find sovereignty as a defender against rule of law, interpreted as this instrument, as this tool against good causes. So you have well understood. I have had a provocation. I can understand your point. I accept partially your point as a way of explaining today. But I, however, wanted to explain that there is a risk in viewing the situation in such a position.
Thank you. I mean, risk is part of life, so that's true. Getting back to Albania, I just wonder whether the situation in Albania is not unlike the situation in Hungary, maybe in the 1980s, when you had a situation where there was this fantasy that everything that comes from the West is ipso facto better than Hungarian, and where people look to the EU and international organizations as like the saviors and looked upon, basically morally looked down upon Hungary itself because of the situation. I just wonder whether that's what's happening in Albania. And maybe, like in Hungary, Albania too can somehow get rid of this addiction towards this Western fantasy that they know better than we do how the world works.
Yes, it's true. It's a similar situation, and I have one example for this that best shows it. 2 years ago, through lobbying, and again without any accusation, the United States declared Berisha non grata in the US. Whenever somebody, even Congressman Lee Zeldin, asked 5 times the Department of State, whenever somebody would ask them, what's the proof? They would say, we have the proof, but we don't show it. And Berisha himself said, present only one proof and I leave politics. And again, no proof. But the US ambassador at that time, very close to the government, you could very well mistake her for a minister of the government, went to the headquarters of the Democratic Party, and when she came outside, she said, I hope, pretty much she said, I hope you as a party expel Mr. Berisha from parliament and from the party, because it would be quite bad if for the sake of one man, the whole party would eat grass. Eat grass is a phrase that the former communist dictator Enver Hoxha would use in Albania. And he would say, we are willing to eat grass before we go against our principles. And it was very peculiar that a US ambassador would use a phrase of the former communist dictator, who was against the US, by the way. And I want to come to the point that maybe we've reached the point where there is this realization in Albania, or at least among some conservatives, that not everything that a bureaucrat who has another nationality except for Albanian, not everything that they say is true or is the word of God. because there was this perception that everybody who comes from outside or from EU institutions should be held as some sort of god. Because when she said that there was irritation, but also a sense of defiance, because in the end, the Democratic Party chose as its leader again Berisha, even though these bureaucrats were against that. And it's them who helped more than anybody Berisha return to politics, because he was near retirement. So with what they did, they actually encouraged him to return. So what has happened in the past 2 years has shown to many Albanians that not every word of every bureaucrat in the world should be followed or listened to. On the other hand, it's true that we still believe that our future, because we are Europeans, and our future is in the European Union, as an equal member of the European Union, in a Europe of nations who are proud of their identity, of their tradition, of their history, and Albania has a lot of identity, history, and tradition. And we hope to join the EU one day as an equal partner with something to contribute. But the bureaucrats, and I end with this, acting like the new monarchs of Albania, these bureaucrats are not helping Albania, and they are not treating Albania as an equal partner. They are treating it as an inferior partner with these actions that they have. So we as conservatives are hoping and working towards that one day we can join the European Union and be an equal partner in the European Union and help this European project become maybe what it was intended to be.
Thank you. We started late, but so I'll let it go on a little bit. But I just want to ask a question from you, which has been bothering me for a very long time, which is I instinctively don't like human rights, right? The concept of human rights, rather than it's what it's supposed to be, because I know that as long as we accept the discourse of human rights, it's going to be used in all kinds of negative, corrosive kind of ways. And I just wonder, have you ever thought about seeing whether it's possible to develop a more conservative, more Europe, kind of one that's kind of more consistent with European morality, traditional morality, kind of sensibility that cuts across this promiscuous invention of human rights that's happening all the time?
So, of course, there is a problem with human rights. I can say the same, that I hate human rights. But we use it as a law because we think that if an Islamist terrorist has human rights and this human rights law and can use these institutions, I think a Christian with a refugee because he converted and that should be sent back to an Islamist country, he needs to have the same rights and the same tools to defend himself. So I see human rights law as a positive law, and at the ECLJ we use it as a positive law and not as the best law we can have. And the main philosophical questions, I would say, in this text of human rights are the first one. It's very individualistic because common goods are considered as limits to human rights. So for each human right, you have one paragraph saying what is this human right, and the second paragraph saying all the limits, and all the limits are common goods, like public health, public moral, security, public order, and in the traditional philosophic way of thinking law, it should not be like that. Rights are ordained to common good, and common good are not only a limit to rights. So there is a hierarchy and a harmony. It's not just tension. And the second main problem I see in this text is the principle of non-discrimination. I think it's a good principle if it applies to race, for example, but it applies to many situations. So there is the non-discrimination applying to religion, for example, to sex. It also raises questions. And there is always other situations. So it's very large. And judges and experts that interpret other situations have the power to have a lot of imagination to create many, many situations where they see discrimination. So yes, I agree with you, and I hope you will be reassured if you know now that when we promote human rights, it's as positive law only.
Yeah, thank you. I think that what you had here was an interrogation of the concepts. I think that the questions really about sovereignty and the rule of law by Miguel is really quite important, that we don't take it for granted. Similarly, the question of looking more deeply into rights and human rights is really quite important, because one of our challenges is to make sure that in terms of our legal scholarship, we're not running behind our opponents, but we're running ahead of them, that we are able to intellectually take the fight to their battlefields rather than the other way around. I think we're now going to have a break, if I'm right. Is there a coffee break or some kind of break? Yeah. And then we move on afterwards. So thanks very much, and thank you to the panel for being so stimulating.
I'm Ellen Fantini. Many of you know me as the managing editor of the European Conservative. I primarily concentrate on running the news and current affairs side of our publication. So in that capacity, I work daily with the rule of law battles here in Europe and the use of lawfare against sovereign countries to achieve political outcomes. Most of you do not know that in my previous life, before I moved to Europe, I was a criminal prosecutor in the United States. It was a profession I was very proud of, partly because of the lessons I learned from my first boss. When I was just a baby prosecutor, just starting out, my mentor and boss emphasized the profound responsibility that rests on the state's shoulders in a criminal trial. He told me that I should always zealously advocate for our client, that is the state, the government, but cut no corners, keep our hands scrupulously clean, and always remember that our significant power requires a high level of moral rectitude and responsibility. He said if we win a case, that is, convict a person of a crime, justice has prevailed. But if we lose a case, that is, a person is found not guilty of a crime, justice has also prevailed. Why? Because we cannot believe in a justice system only when it benefits us. That's not justice. Similarly, I also remember when colleges, universities, and law schools were incubators for ideas, where unpopular opinions were debated. Free speech was encouraged, and discussion was a sport, let's say. I remember having vigorous debates, followed by sharing a beer with those people with whom I just disagreed. So all of that has changed. Higher education has weaponized administrations, rules, policies, specific policies against dissent. And this is, of course, also a form of lawfare. And lawfare, that is, using the law to achieve political objectives, prevails across institutions. The power of the prosecutor has been weaponized by rogue prosecutors. The law itself has been turned into a weapon against wrong thinkers and political opponents. And all of this has happened in a place that has been considered by many to be the world's beacon of freedom, the United States of America. So I'm delighted to introduce my esteemed panel to discuss these issues. I'm joined on stage by Patrick Gray, Dean of the Center for Arts and Letters at the University of Austin in Texas. John Yu, who's Emanuel Heller Professor of Law at the UC Berkeley Law School. And Charles Cully Stimson, Senior Legal Fellow at the Heritage Foundation. So each of them will give some opening remarks, and then we'll have a discussion, including questions from the audience. So that's a way to energize us in the final event of the afternoon, and to have a chance to talk to some real experts in their field. Just as the previous panels were experts, now you get to talk to them. So do jot down questions as they're speaking, and we'll have a microphone circulate after the opening remarks. So, Patrick, the floor is yours.
Hello, everyone. It's great to be here. It's great to be back. I spent a year in Budapest not too long ago and loved it. So I'm going to talk about universities, not always exactly lawfare, but analogs of lawfare in terms of codes of conduct on campus. So the most obvious example of lawfare on American campuses today is the selective prosecution of so-called hate speech. You know, if you are white, male, heterosexual, and or Jewish or Christian, then you are held to a more stringent moral standard. People can say all sorts of vile things about your kind of people, but you can't reply in kind. You know, you can say bad things about white people, Jews, men, but not the reverse. So this is a kind of selective prosecution. We see similar things with selective prosecution of different student groups or associations, such as fraternities or sports or so on campus. This spirit of division dates back most immediately, I think, to the presidency of Barack Obama. Obama was elected in a spirit of racial reconciliation. But as his initiatives faltered and as his popularity began to wane, unfortunately, he rekindled an old demon within the United States, the sort of spirit of 1968 with all of its attendant racial strife. Now, some might say this was an effort to shore up his base. Others might say the mask of the radical began to slip. But in any case, it was not received well by the public. The response from the public was to elect his polar opposite, Trump. Now, as you might imagine, Obama's allies in higher education have not accepted or internalized this popular rebuke. Instead, they have accelerated their weaponization of American universities as an instrument of political opposition. But I think that their impatience in doing so may prove their undoing. Up until about 6 months ago, the far left had been very successful, not only in transforming higher education into a training ground for far left activists, but also in doing so quietly and incrementally without alarming people such as parents or donors or trustees or especially legislators who might have been able to exert effective countervailing pressure. All of that changed in the wake of the attack on Israel on October 7th. To the horror of most Americans, protests broke out on the campuses of America's most prestigious universities, denying the events of October 7th, denouncing Jews, and calling for an end to Israel's existence. This revelation of pervasive anti-Semitism, a ghost that many thought had been put to rest, came and continues to come as a shock to the American public. And people are asking, what went wrong? How did things get so bad? Meanwhile, despite violence, insults, harassment directed at Jewish students, university administrators have seemed oddly reluctant to step in and restore order in the way that they have done in other cases. The presidents of Harvard, MIT, and the University of Pennsylvania were called before Congress to explain themselves, and as is now notorious, their answers were, to put it charitably, evasive. They insisted that calling for the genocide of Jews could be permissible depending on context. I'm quoting here. More precisely, they claimed, And arguably, they are technically correct that it is within the bounds of free speech to call for the death of all Jews, as long as that general call for the elimination of the Jewish race is not directed at any one Jew in particular. Not an appealing conclusion. Afterwards, so what did the commentariat make of this? Afterwards, commentators were quick to point out that it was patently hypocritical for these college presidents in particular to take refuge in what Harvard President Claudine Gay described as, quote, a commitment to freedom of expression. Harvard in particular is a notorious, maybe the most notorious example of contemporary cancel culture, including not only the practice of shouting down or disinviting speakers, but also shunning, ostracizing, harassing, and denouncing faculty in an effort to secure their resignation or suspension or dismissal. Okay, so that's the status quo. What is the problem here, and what is the solution? To one way of thinking, the problem is censorship, and the solution is free speech. Universities should commit themselves to a set of conclusions known as the Chicago Principles, which enshrine a right to freedom of expression for not only for students, but also for faculty and administrators. These principles were adopted by the University of Chicago 10 years ago, and since then, the Foundation for Individual Rights in Education, a nonprofit also known by the acronym FIRE, has been leading a campaign to encourage other universities to adopt the same. About 108 have signed on, and the campaign continues. Now, on the one hand, I admire what they're doing, and I think it's well-intentioned. At the same time, what I would like to propose here, at the risk of some controversy, is that the Chicago Principles are both inadequate to their set task and fundamentally misguided. Okay, all right. Maybe not as controversial as I thought it would be. Okay. All right, okay. That's good. Okay, all right, I'll keep on going then. All right, so the Chicago Principles are inadequate to their set task because they do not require any mechanism for enforcement. So, and I think as the example of so-called international law very vividly demonstrates, supposed rights and supposed rules are nothing more than wishes and fairy tales unless they can somehow be enforced. But, okay, so let's talk about enforcement. At the University of Austin, we address this problem by introducing what we call an adjudicative panel, analogous to a Supreme Court, that serves as a check on the faculty, the deans, the president, and even the trustees. Anyone in the university who feels that they have been treated unjustly or out of keeping with the Constitution can appeal to this adjudicative panel, and they can trust that their case will be considered by a group of people who are financially and politically independent of the university. I think that's a good innovation. But I also think that this kind of panel is only part of the solution, because even if the Chicago Principles could be perfectly enforced, they would still be wrong-headed. The goal that they advocate, quote, freedom of expression, is intrinsically irreconcilable with the very nature of what a university is, as distinct from a state. So, to clarify, I think we all recognize that free speech is essential to the healthy functioning of a representative republic. It's in a democracy, everyone should be able to set up a soapbox on the corner and say almost anything. No threats, no slander, but really anything else should be fair game. This manner of proceeding, although healthy for a democracy, for a nation state, is incompatible with the necessarily hierarchical structure of a university, as well as the actual practice of academic research and instruction. So, for example, why does one student get an A and another gets a B? Why does one article get published but another doesn't? Why is one subject optional but another subject is required? This is the day-to-day business of a university, and it does not, and in fact it cannot consist of allowing anyone and everyone to say whatever they please. Instead, universities require, as their central exercise, constant subjective assessment and regulation of other people's speech. Now, I pause here because I think this point can be very difficult for classical liberals to wrap their minds around, right? A university, like a book publisher, or a movie studio is a second-order phenomenon, right? A state is a first order. These are second-order phenomena, universities, presses, studios. It can only ever be a giant mechanism for what is, in effect, a kind of soft censorship. Some speech is rewarded, other speech is not. So, for example, the University of Austin is not, quote, a free speech university, because a free speech university is a contradiction in terms. No such thing can exist. Our Constitution does not include the phrases free speech or freedom of expression because these goals are incompatible with the provision of a coherent and substantive education. So, why do I bring this up? What I want to stress today in this setting is that when it comes to universities, freedom of expression is not what we should be fighting for. Free speech, in the sort of American First Amendment sense, is not possible at universities. It's a distraction. Instead, what we should focus on is the standard by which speech at universities is sorted and prioritized and rewarded. What are the criteria for advancement, and how are they enforced? That is the real battleground. Who decides, and on what basis, what is good and what is bad? Again, to emphasize the point, in the context of universities, something like censorship, in one form or another, is inevitable. We can call it selection. We can call it curation, right? But it is akin to censorship. We are essentially saying not all points of view are equal. And I think we need to make our peace with that because it's only after we understand that censorship is not the problem that the real problem comes to light. And the real problem is a dangerous misunderstanding of the purpose of higher education. For too many people on American campuses today, the consideration that trumps all others is identity politics. To their mind, an expression such as an essay or a protest is good. Attending a protest, for example, why would someone give extra credit for that? As often happens, as we were talking about. It's true, it happens. It's good because, for their mind, the criterion of good is not the articulation of any kind of objective truth, but instead a reversal of the roles of oppressor and oppressed. That is to say, an essay is good or a protest is good insofar as it seems to redistribute power from the strong to the weak, or rather, let's say more precisely, from the classes they call privileged to the classes that they deem marginalized. Insisting on freedom of expression will do nothing to solve this problem. Well, it might do a bit, but it's not the core of the problem. What we need instead is a robust, alternative vision of what education is. What is the purpose of higher education? What are universities for? Why do they exist? When it comes to private universities, our guiding principle should not be free speech, but instead freedom of association. A state can put in place an iron curtain that prevents its citizens from escaping, but no one is forcing students or faculties to be part of particular private universities. If they don't like the way their speech is regulated, they can leave or do what we did. They can set up their own different private university somewhere else. What we should require of private universities is truth in advertising. They should state what their mission is, and they should be obliged to stick to it. So a university like, say, Harvard, whose motto is Veritas, truth, well, that should be their focus, not social justice. When it comes to public universities, by contrast, we need to insist on the rule of law properly understood as a counterweight to the principle of academic freedom. Faculty working at universities that are subsidized by the state should not have any more say in determining the purpose of those universities than any other kind of citizen. For example, by way of analogy, one might look to the military or to the civil service. Even a Secretary of State, even a 4-star general, only has one vote. For example, imagine if soldiers insisted on, quote, military freedom, by which they meant that, since they know a lot more about tanks and guns than the rest of us, they should be the ones to decide whether or not we invade neighboring countries, right? We would rightly conclude that they had confused their domain-specific expertise with a more general kind of wisdom. I think likewise, academic freedom should be understood as extensive but not unlimited. in fairness, Western militaries owe much of their success to our custom of allowing officers great flexibility in how exactly they carry out their orders. Nonetheless, we insist that military officers take their objectives, their guiding purpose and objectives, that they take that from the civilian government. The same should be true of the civil service, and the same should be true of academic staff at public institutions. Hungary has been a leader in this respect and inspired changes along these lines throughout the United States. State legislators have been introducing multiple new, quote, schools of civic thought within flagship public universities such as the University of North Carolina, the University of Florida, Arizona State, Ohio State, many, many more. There's about a dozen of these now. There's another half dozen coming online soon. These schools provide an alternative vision of what a university ought to be. A university exists to provide knowledge for the citizen of what their political system is, what their culture is, and how to make informed decisions within that system. It lets us bring in things like great books, Athens, Jerusalem, Rome, the history of England, because we are helping students to understand the system in which they operate, a system that emerged out of that specific history. So as time goes on, I think conservative populism will continue to gather momentum, and opportunities for similar changes will occur in other countries. One that comes to mind is Australia, where the Ramsay Center for Western Civilization provides a proof of concept. I think other countries in Europe will perhaps follow suit, like Hungary. We were talking about Poland earlier being a possible example. I think it will be a long fight, but I do think, and I look forward to seeing the day when, I look forward to seeing legislators take back our public universities and restore them to the service of the people. Okay.
Thank you. It's great to be here. This is my first time in Eastern Europe, actually, not to mention Hungary. And yeah, and I wanted to see what all the buzz was about, because I've met so many conservatives in the United States who said, "Oh, it's just over in Hungary," and we debated about this. And I met the most interesting person in Hungary. We talked about that. So I wanted to see why Hungary has become such a center of, I think, aggressive conservative thought. And I realized what it is. It is family businesses. Because I've had the pleasure of seeing John and Melissa, and now I realize that Mario and Ellen run the other pillar of conservatism in Hungary. And I knew European business is founded on family businesses, but you're taking this really way too far. I wonder if is it the Center for Fundamental Rights? Do you have a spouse who's also working in the family business too? That would be perfectly symmetrical. I also wanted to come here because after people always say, what's it like to be a conservative professor at Berkeley? And after listening to the panels, I think you guys know what it's like because you're Hungarians within the European Union. I feel like exactly the way you do all the time. Like, what is the latest crazy thing that the people, the powers that be, are going to think of? Right? It's a very, but I think this is a healthy thing to be the dissenting minority in some larger progressive enterprise. And I think being a place, actually, I think all of us who are in universities have that feeling. There's no conservative university in the United States. So if you're an academic or a scholar, I actually feel like we share the same perspective in a way that Hungarians share towards what I was hearing this morning about the EU, for example. I don't know if that's worth clapping about, but it's certainly, I feel the same kind of perspective there. So I'm just going to talk very briefly about the Trump trials and what they mean for the rule of law. And the basic thing I was going to say is in the American system, it actually sounds similar to me. It does have some commonalities or similarities with the Hungarian and European experience, is that the rule of law, to me, is not a principle that we should rely on the courts or constitutions to actually enforce. If you look at the Trump trials, the real guarantor of fairness, of the rule of law, is through the executive branch, through the prosecutors, through prosecutorial discretion. And what we've seen in the last 4 years is the loss of, I know now these Straussian guys are going to love this, statesmanship, prudence, leadership, right? These are not really values that are enforced. Why am I attacking? Because whenever I teach with these guys, those are words they use when you argue with them and they can't explain themselves, and they say prudence, statesmanship, leadership is. But these last 4 years, I think it's true. The reason why all these trials have beset Trump, and I think are ruining our system, our political legal system, is because we have had a vacuum of leadership, political leadership. And when you have that vacuum, the legal system will just naturally expand and occupy it. But the problem is the legal system is binary. You have winner and loser. You have convicted or acquitted. And it removes the space for political compromise. And I think that's what you're also seeing in the United States. So letting a political vacuum form because of an absence of prudence or leadership allows the legal system to come in and make fundamental decisions for the society that would be better off made by democracy. But it actually leads, I think, to this kind of polarization that everyone's worried about. So let me just briefly explain how that's happened in the United States with the Trump trials. I'm happy during the Q&A to go through all the trials. I know them all very well, in and out, all 4 of them. There's really actually 5 of them, but I'm happy to talk about those in detail. But if you think about it, it's not like we haven't had presidents who have committed crimes before. It's not that. The thing that we've had with statesmanship is that we never chose to prosecute them before. So just to give you 2 examples that I think are obvious cases. George Bush, the president I worked for, when he came into office, decided not to prosecute Bill Clinton for perjury, right? Bill Clinton committed perjury. He just wasn't impeached by the Senate. Actually, after he was president and left office, he had to withdraw from all the bars he was a member of because he had committed the crime of perjury. George Bush, if he had the same attitude Joe Biden did, could easily have ordered the prosecution of Bill Clinton. I don't even think it would have been a close case. Donald Trump, right, who's now on the receiving end of this, he entered office, he could have ordered the prosecution of Hillary Clinton, right? Think about, if you talk about the documents that President Trump kept. Remember, Hillary Clinton had tens of thousands of classified emails in an unclassified server. The facts of this were not really in doubt. She committed 10,000 violations of the federal classified, there's no federal classification statute, of the Espionage Act. Donald Trump did not say, oh, let's go after my main rival, too. He didn't make a big deal of it, but no prosecution went forward. Even though he had campaigned on lock her up, right? He did not choose to lock her up. They could have put her away for thousands of years, actually, especially if you charge things the way the Biden administration is charged, which is every single document is another violation. Right? Or even go farther back. Gerald Ford pardoned Richard Nixon. Right? People say, Steve's the expert on this, but Ford lost the election barely. And many people say if he had not pardoned Nixon and actually had prosecuted him, he might well have won re-election. I think actually it's one of the great moments of American statesmanship that Ford said, we're not going to go after Nixon, we're going to give him a pardon, and we're going to look to the future. Another reason this is important, because think of the effect these prosecutions are going to have on future presidents. Because now that we've crossed this Rubicon of prosecuting presidents, I think the only way to stop it is for both parties to continue to do it. Unfortunately, I think Republicans are going to have to prosecute Democrats, because if they don't, the Democrats will never stop. And you won't have a restoration of some kind of deterrence. And so I am always right, Hadley. You haven't learned that by now. No, but I think that's the case, is that you're going to have the need for tit for tat, reciprocity, or retaliation, unfortunately, is what's going to have to happen to actually stop this from continuing. But think about what's going to happen to the presidency while we go through this. One of the important reasons why we've not prosecuted presidents in the past is because we don't want them to be thinking about being prosecuted when they make important decisions. You know, you don't want presidents to be insurance claims adjusters, right, who are always wondering about the risks of accidents, right? You don't want presidents like President Obama, when he has to decide on a drone strike, to be worried about being prosecuted by his successor if, for example, he kills more civilians in the strike to get a terrorist leader than his successor thought was the appropriate amount. We're going to have a risk-averse presidency while this continues. I think that's going to be a really harmful to the protection of American national security. Why is this idea wrapped up in the prosecutor rather than the courts? One point, I think maybe the greatest prosecutor in American history was a fellow named Robert Jackson, who was FDR's Attorney General and then became a Supreme Court Justice. He gave a speech that's considered the classic expression of the prosecutor's mindset. It's just called the federal prosecutor. Under the US Constitution, the power of prosecution is vested in the president. The president is the chief prosecutor for the United States. He delegates that authority to the Attorney General and down all the way to the very lowest federal prosecutor. Right. Jackson made the point, which I think now that I've seen what's going on in Eastern Europe, I see this in Eastern Europe too. Prosecutors don't even have to get to court before they can destroy somebody. They can ruin someone's reputation just by launching an investigation. And that's one point Jackson makes is, he said, in civilian life, the prosecutor is actually the most powerful of all civil servants, all government officials, because any prosecutor can destroy the reputation of any individual at any time and never be held accountable. Just interviewing people, he said, about a potential target will lead to rumors and gossip about that person in the community and probably ruin that person's reputation. And then he said, think about what happens when you actually choose a case and prosecute them. Even if they're acquitted, often the reputation can be damaged. That's right, clearly what's going on in the Trump cases right now, just a desire to harm his reputation. And so Jackson said the real limit on that power, it's not the judges, because if the case never goes to court, the judges never see it. He said the only limit on that power is the professionalism of prosecutors themselves. And he said the worst thing you can do as a prosecutor, he's quite prescient about what's happening in the United States today, is to pick someone who is unpopular or pick someone you hate because he's a member or she's a member of a group you dislike and prosecute them just because of who they are rather than the crime they committed. And isn't that what's happening to President Trump right now? Prosecutors have picked him, and then they have found the crime afterwards. You might remember this was Laurentine Beria's favorite way of explaining how the Soviet Union's government worked was he said, show me the man and I'll show you the crime. And that's what Justice Jackson was warning against, that the executive branch prosecutors in America should not ever cross into that line. But isn't that where we are now with the Trump trials? In the past, again, presidents have no doubt done things that could be prosecuted. But we've had other presidents who had the good sense for 240 years not to cross this line and prosecute their predecessors, not to cross the line and prosecute their main challengers. And the last thing I'll say before I end is and you're seeing the sloppiness of it right now. All of these cases are actually imploding because they were done so sloppily, because the prosecutors picked a person and they didn't pick the crime. And so they have engaged in this mishmash of conjured up crimes that have never been prosecuted before. I think many of them will never be upheld on appeal because they don't fit the facts of what Donald Trump did or not. And so that's why, just take one example, the Atlantic case, which I call the real prosecutors of Atlanta, where you have the head DA of Atlanta is having an affair with the prosecutor who's been appointed to investigate Trump and has paid him $600,000, right? Which they can't show any bank statements, it seems, because apparently prosecutors just keep lots of money in cash bags around the house which they both said under oath before a judge. Right? What was the crime they made up? They said that President Trump's re-election campaign, the whole thing was an organized crime racket, and that everything they did, starting from the time of the election all the way through the inauguration, was an effort to further a criminal enterprise, which, you know, talk about a violation of the free speech clause. It would be for prosecutors to say an election campaign itself was criminal, right? That's ridiculous. The one that's going on right now with Alvin Bragg, totally made up, right? Still, the prosecution has not explained what crime has been committed. The crime you're seeing on TV or reading about TV, that Donald Trump allegedly paid a woman who takes off her clothes on TV for money. So someone like that, in exchange for a non-disclosure agreement, that's actually not illegal. But the prosecution has used this kind of reality TV show approach to a trial to shock the jury and the public into thinking Donald Trump's such a bad person, he must be guilty of something. The only case I think is actually a legitimate and important case here would be the January 6th case. If President Trump really did participate in a conspiracy to overthrow the government, then I would think that would be a valid prosecution. It would be the most important criminal case in the history of the United States. But you know what? The prosecution has charged Trump with committing fraud against the United States, not trying to commit an insurrection. We usually use fraud to charge people who have stolen money from the government by overcharging the army for helmets or charging Medicare too much doctor time. He did not commit fraud. He wanted to be president, but he didn't commit fraud in the sense he tried to steal money or property from the government. They've also charged him with tampering with evidence before Congress, which the Supreme Court, I think, is shortly about to say doesn't apply to January 6th at all and is about to strike that charge down against all 400 or 500 January 6th rioters. And then the last charge, I think, is actually the most outrageous, is they charged Donald Trump with depriving every American in the United States of their constitutional voting rights simultaneously. So I don't know if any of you felt that happen when you voted, but when I voted, I did feel some voting rights slipping away a little bit. But this argument is Trump, by trying to get the electoral vote counted in his favor, prevented all the Americans from voting for president. Of course, under that theory, the Electoral College is also a massive voting rights violation because it does not purely transmit majority votes into the selection of president. Anyway, I hope by just giving you a small rundown of the trials, you can see what's happened is that prosecutors, who I think really are the ones who guarantee the rule of law in the United States because of our Constitution's vesting of prosecution in the presidency and in the executive branch, have failed to do their job. Not just by bringing the charges, but by showing the necessary restraint that we use to treat equal cases equally, but also to protect the institution of the presidency. Thank you very much. I look forward to the questions and our discussion.
Well, it is an honor and pleasure to be here. And I have to admit, when I got an email from Istvan Kiss that people in Hungary were interested in my book, Rogue Prosecutors, How Radical Soros Lawyers Are Destroying America's Communities, I was surprised because I just didn't think the book had much interest outside the United States. But then the more I thought about it and talked to my colleague Chris DeMuth and others, I realized obviously Soros has been up to no good all sorts of places. Then I thought, well, maybe there's a more base level for the invitation. My name's Cully, John O'Sullivan, the Irish connection. I figured maybe there's some camaraderie. And then the day that Istvan sent me the official invite, I opened up my Ancestry.com genetic profile, and sure enough, it turns out I'm 41% Hungarian. So I figured I'm coming home. I've been asked to talk about, and I think I want to extend John's conversation to really the granular level of what's happening in the United States. and how the rule of law and the application of the rule of law has been warped and distorted beyond recognition, beyond anything that we've ever seen in our country's history. But to do that, you need to step back and sort of understand how the American criminal legal system differs from anywhere else in the world. In England, you have the Crown Prosecutor. The Crown Prosecutor has various offices around the country, like other European countries, and there's one prosecutor agency for the whole country, right? That's not the way it is in America. In America, you have the federal prosecutors, and there are only 94 U.S. attorneys spread around the country. They handle about 10% of the crimes in America. 90% of the crimes, the standard, crimes you would think of, murder, carjacking, burglary, and that sort of thing, are handled by local district attorneys who are elected. And we're a big country. We have 3,143 counties. And spread among those 3,143 counties are 2,300 elected district attorneys. So can you imagine, to John's point, if a Democrat gets elected president in the next cycle, or this cycle, and a Republican district attorney from a random county wants to lash out, what is to prevent a Republican district attorney from simply filing common law crime, allegations of crime against a Democrat president? Nothing, really, except integrity and fidelity, or prudence, right? And so let me lay the groundwork for how Soros and others who've been funding this so-called progressive prosecutor movement, which started in 2017, what the origin, playbook, and belief of this movement, why it's pernicious, and then what the results have been. First off, the prosecutor, all 2,300 local prosecutors and the 94 U.S. attorneys, are the gatekeepers to the criminal justice system. They, and they alone, decide who gets prosecuted and who doesn't. And their decision is basically unreviewable. If Steve decides as the county DA in County X that he's not going to prosecute Hadley, who's richly deserving of being prosecuted, that's it. He's not getting prosecuted. You can't appeal that. The other thing is that the elected district attorneys in the various counties in our country, these elections are low visibility, low dollar affairs. Literally $10,000, $15,000 is the about average amount of money that is spent in an election of a DA. 95% of DAs' races are uncontested. Even in the largest cities in this country, Chicago, LA, Philadelphia, $1 million is an exorbitant amount of money for a DA's race. And so Soros realized, and the people advising him, realized that they could literally buy themselves a DA for a small amount of money. Let's step back. America has a crime problem. Let's just be honest. Even though we've had the lowest crime rate since the last peak in 1992 for 25 years, we still have a crime problem. And I looked up some statistics here in Hungary. In 2021, there were 94 murders, homicides in Hungary. There were 562 in Philadelphia alone. All right? We've had over 20,000 homicides per year, usually about 23,000 per year in the United States going back decades. Let me give you another example. In 2021, there were 561 car thefts in the entire country of Hungary. There were 11,341 in Philadelphia alone. Understand that a lot of car thefts go unreported in America because people just realize, well, I'm never going to get my car back, so I might as well not report it to the police, and they just put in a claim through their insurance companies. And so the reason crime rates went down from 1992 for about 25 years is because states passed more and more draconian laws to punish recidivist criminals. And that's the stick part. And the carrot part, they created alternative courts, domestic violence courts, family justice centers, drug courts, and other alternatives to incarceration to encourage people to get on the straight and narrow and put their lives back in order so they could become productive members of society. That was working. It was working brilliantly. Doesn't mean we didn't have a crime problem. We did, but they were the lowest crime rates we've had and the lowest incarceration rates we've had in 25 years until 2017. And the rogue prosecutor movement is motivated by two distinct beliefs. One, that the entire American criminal justice systems are systemically racist. And two, that the only way you can fix that original stain of slavery and the racism that's embedded in the criminal justice systems across the country is to reverse engineer and, quote, dismantle the criminal justice infrastructure. That's Rachel Barkow's language, not ours, and we talk about the origins, playbook, and belief in the first chapter of our book. And how do you do that? We have an adversarial criminal justice system. You have a hard-charging ethical prosecutor against a hard-charging ethical criminal defense lawyer. You pit those two in front of a jury of their peers, in front of a neutral detached judge, and let the chips fall where they may. Guilty or not guilty, justice is done, to Ellen's point, right? But if you want to change the system from within, if you want to, quote, open the locks of the prisons, which is their goal, one of their quotes from their cheerleaders, you replace a hard-charging, independent, fair-minded prosecutor with a pro-criminal, anti-victim zealot, because that person is the gatekeeper of the criminal justice system. That person could decide not to prosecute. So this is their playbook. Their playbook, and by the way, you may or may not have heard of a woman named Angela Davis. Angela Davis wrote a book called Are Prisons Obsolete? And there is an active Marxist-inspired anti-capitalist movement called the prison abolitionist movement in America. It's a wacky fringe movement, but it's now mainstream, and it's reified in the form of the progressive prosecutor, or what we call rogue prosecutor movement. They think that all prisons should be abolished and all police departments should be defunded. They just believe that. They don't propose an alternative, of course, but that's what they believe. Let me tell you what their playbook is, and then let me show you some of the results, and then I'll sit down. First off, once they elect one of these so-called progressive prosecutors, these rogue prosecutors, they issue a memoranda to all their district attorneys, their line prosecutors, to refuse to prosecute all misdemeanors. And when I mean refuse to prosecute them, don't prosecute any. So you see videos from San Francisco and all sorts of other cities in the United States where people are shoplifting with no consequences. They'll list crimes that you can commit in the city. So receiving stolen property, breaking and entering, malicious destruction of property, drug possession of any type. And we have a massive fentanyl scourge going on in our country right now. It's the number one killer. And yet they're letting people do that. Resisting arrest, these prosecutors hate the police. And of course, police don't like them either for that. Most auto offenses, drunk driving, etc. They order their prosecutors to water down most felonies to misdemeanors. They don't ask for cash bail. They don't let their prosecutors ask for cash. Cash bail is posting 10% of a dollar value to guarantee your return to court. But they think that's a poverty penalty. It's a fancy little word they use, and so they don't ask for cash bail. So Hadley gets arrested again for something terrible. Excessive stripes on his suit, it's a crime. And he presents him in front of Judge Mario Fantini, and the judge says, you can leave, no cash bail, and you're asking for $100,000. They just walk out. So you see this revolving door of the criminal justice system. It happens over and over and over again. They don't allow their prosecutors, even though state law requires it, to add sentencing enhancements, gun enhancements for repeat offenders. They don't allow violent juveniles, 17, 16-year-olds who commit murder, child abuse, etc., to be tried as adults, even though the state law allows it. So what's happening is not an exercise, a proper exercise of prosecutorial discretion. It's an exercise of prosecutorial nullification, which is a complete violation of the separation of powers, right? Prosecutors sit in the executive branch. Their job is to faithfully execute the law with proper discretion, but that's not what they're doing. In my remaining couple of minutes, let me just show you just from visual charts. Like I said, there's 2,300 elected DAs across the country. 74 are Soros bought and paid for. And in the city, this started in 2018, in the cities where they have the toxic trio of defund the police, Soros bought and paid for rogue prosecutors and this sort of demoralization of the police, murders and all other crimes have spiked substantially. This is Chicago, starting in 1992 till today. Blue is crime rates going down. This is murders in Chicago. And of course, you see the second, Kim Foxx, the first rogue prosecutor, murders go up. So this all happened before the pandemic. You'll hear in the liberal press that the pandemic actually caused crime to rise. No, crime was rising in other cities well before the pandemic. Philadelphia, murders by year. The second Larry Krasner gets elected with $1.72 million of Soros money. Murders go up. And the same with in Philadelphia, shooting incidents per year, etc. All right. The sad irony of this movement, and I'll leave you with this, is that they wrap themselves in a warm cocoon of civil rights type language, and they pretend that they are doing this to end the scourge of so-called racism in our criminal justice system. And the vast majority, well over 90% of the victims of this failed social experiment are minorities themselves. That is why that's why this movement is starting to fail. That's why you're seeing people like Chesa Boudin in San Francisco, Marilyn Mosby in Baltimore. Alvin Bragg is one of these rogue prosecutors. The prosecutor down in Atlanta is one of these rogue prosecutors, but you're seeing others either get voted out of office or be under pressure. Look forward to your questions.
Okay, we have just a couple minutes. We started a bit late, but I will try to respect our time here. Questions from the audience. There's so much interesting material to ask about. I'll take a couple questions. You can grab the microphone from there. A couple questions. We'll pause. We'll get some spicy answers and repeat until we get kicked out. Okay, so we see two here and then two there. You can start with these guys over here and then move over there. Quick questions, to the point.
Don't worry.
Thank you.
This is just a question to Professor Yu. First of all, just very briefly, I've really enjoyed your sparring with Richard Epstein over the years, so thank you for some fun listening. My question is just...
I love that he has an audience.
a big UK audience. So you mentioned the cases imploding, the various Trump cases. And it seemed to me like you have faith that the judicial system will win out, if I can put it in that way, in that even if convictions are successfully secured, they'll get overturned on appeal. So you seem to have a kind of an optimistic frame of mind, but I'm wondering, what do you think things are going to look like in 20 or 30 years' time, when all of these law graduates who've gone to law school are going to come through the system and, I assume, have been taught kind of woke social justice kind of theory? Is your faith in the judicial system going to survive in the long term, I guess? That's my question.
Good. Okay, next question, and then we'll move over here, and then spicy answers.
Sure. Question for Mr. Gray. I love what you're doing at the University of Austin. I remember when I first read about it in the Free Press, I was very excited. It's an important alternative. But maybe the paradigm is more broken more generally. That is to say, how much of the problems we're seeing arise from the institution of four-year college, and there not necessarily being enough education to fill that up. And that is to say, college being essentially kind of like a cruise with lots of free time and optional activities that will be filled up with junk. And maybe it's the institution of the four-year college that is not professional education, not a technical education, as an assumption for the masses is what needs to be rethought.
Great question. One more here, and then one more there, and then we'll go to the panel.
This is a question for Patrick Gray. What do you think of the patriotic frat boy reaction to the pro-Palestine protests on American campuses recently, and do you think it represents a new strain of right-wing thought in America?
Okay, and if you could just pass the microphone there.
What do you think about the prosecution of Julian Assange in regard to freedom of press and freedom of speech?
Great. Okay. So, John Yoo, case is imploding now, but what's going to happen with a bunch of young woke prosecutors 20 to 30 years down the road?
Yeah, actually, I was trying to make the point that the political and legal culture is actually more important than the judges. And so I think you're right that you look 20, 30 years down the line, if things keep going in the direction they are and conservatives don't succeed in arresting it and turning it around, that it could be much worse. I actually don't have a lot of faith in judges. I have a lot of faith in, actually I have more faith in juries. I think that is one thing that is not really known in the European system. But I generally, you could have an abusive prosecution, which I think you're seeing, particularly this New York judge in the Trump trial right now is being extremely favorable to the prosecution. I don't know whether I think he's personally biased the way President Trump obviously does, but he's just very pro-prosecute, like excessively pro-prosecution. But all it takes is one juror out of that 12 to say, I'm not going to convict, and he's not convicted. I mean, gets hung jury. But so I still think the American people, if they're truly picked, 12 of them are random, I do think they represent a sort of common sense of the community. I think actually it would be great for Europeans to introduce juries for criminal cases, because your solution to this problem in a lot of countries is to put the power of prosecution in unaccountable judges, which I think would be a total disaster if you did that in the United States, to let judges run the prosecutions too. So I think the juries are the real check. I mean, they're a pain in the neck. I mean, a lot of the reasons our cases go on so long is because we have to properly present things to juries, but they are the ultimate check on the power of the government.
So, Patrick Gray, 2 questions. Is the 4-year college a broken paradigm? Do we need fewer or more of them? And then my notes say Pat Frat, but I know what it means. Patriotic fraternity, response to the pro-Palestine protests. Is this a good thing, a sign of things to come? What do you say?
These are good questions, and I think they're more related to each other than they may seem on the face of it. So what we're dealing with now is an effort on the part of the left to push everyone to go to college, and everyone to go to college. And for college to be a inculcation of progressive activism. So what do we do about that? And so I think that the one tactic that has been done on the right is to try to ban things like critical race theory. I think that I understand the intentions behind it. I think that's not actually the way to go. I think instead, the better strategy is what I would call crowding out the nonsense. So you limit the bandwidth, not just in higher education, but also in K through 12, and you fill it with substantive things. As a legislator, you say, students need to learn economics and civics and mathematics and organic chemistry and so on. And there's only so many hours in the day. By the time you've learned all that, by the time you actually study the details of American history and so on, there's not that much time left over for, activist studies or, trans this or woke that or whatever. Yeah, exactly. For the end. And I think likewise, this is very important to do at the K through 12 level. Right now, there's a lot of nothing that happens at K through 12 other than just progressive indoctrination. And as a result, people need remedial college work in order to do things that really they should be learning when they're in 8th or 9th or 10th grade. I agree with you. I don't think most people should go to college. I think for most people it's a waste of time. It's a waste of their earning years. Much of that work should be done in middle school and high school. At the same time, I do think that there will always be an elite in every country that does need something like a college education. And so I think the answer there, and this taps into your question about the fraternities, again, control the bandwidth, crowd out the nonsense, provide an alternative on the open market of student choice. And that is why these schools of civic thought, like the ones at UNC or UT Austin, or our new private university, the University of Austin, are rightly seen by the left as a existential threat. Because they know that students at a college, if they are given a choice, many of them will gravitate towards an alternative curriculum. So we don't even necessarily in many legislative situations, you can't solely dictate the curriculum, but you can dictate saying this university must at least offer what we would probably all consider a substantive education. And the more students gravitate to that, the more this other sort of nonsense kind of dwindles down because of students like those patriotic fraternity brothers.
Cully Stinson, let's talk about Julian Assange.
So imagine during World War II, a civilian working on behalf of the Nazi Party convinced a mentally ill American service member to give up the plans for D-Day, preyed upon him, gave him access to passwords to get that, and then weaponizes that and publishes it and destroys the ability of America to invade on D-Day. It's not much different, frankly, than Julian Assange, who preys on a very weak and vulnerable young man named Bradley Manning, later Chelsea Manning, helping him break the passwords to get into a classified system, at which time he then disgorged that to Assange, who then displayed it for the world to see, including 250,000 classified documents from Guantanamo Bay on detainee files, over 500,000 sensitive and classified emails called cables with State Department, and other information including drone and other footage, actual wartime footage, which resulted in service members and allies helping us be killed. That's what he did. And so I think his prosecution is entirely appropriate. I know that there have been a series of back and forth, and the main gravamen of his complaint is that if he comes to the States, he wants to avoid the death penalty. And this administration has assured him through proper channels that he would not suffer the ultimate punishment, which, frankly, I think he deserves. If he comes to the United States and he gets prosecuted by a federal prosecutor, or he pleads guilty, that president or the next president could pardon him or commute his sentence. But it's well past time for him to face the music, in my opinion.
Okay. Two more questions, short ones, and then we should wrap it up. Okay, so one here. Okay.
Short challenge we're having.
Okay, David?
A very short question. If Mr. Soros is going to fund DAs, why can't we do the same?
Okay. While we're getting the microphone up there, an answer can begin.
Yeah, so there's actually, it's a great question. And by the way, in our second chapter, we trace the $50 million in direct spending that he has spent electing DAs, and the $1 billion, with a B, dollars he spent in indirect spending, none of which was illegal through state political action committees, et cetera. And so there's an alternative PAC now, Political Action Committee in the United States, called Protecting America's Action Fund, which is doing the same, but they don't have the billions that the Soros Network did. So as long as it's done legally, and it can be, the pendulum is starting to swing back. There's nothing to prevent that at all.
Question up there, last one.
My name is Dénes András Nagy. I'm from the co-organizing Center for Fundamental Rights, and apologies for closing with a pop culture question, but have you seen Alex Garland's movie Civil War, which is about a civil war breaking out in the US in the 21st century, and how can we avoid it? Because here in Hungary, we very much fear that if the United States turns internally and loses its focus on our region, then this could result in, for instance, the Russian Federation feeling that it is ripe and time to invade the NATO allies here in our region, such as Hungary, Poland, Latvia, Lithuania, or Estonia.
Okay. Has anybody seen it? Does anybody have a quick thought on this concept?
I haven't seen it, but I think these fears of a civil war are really exaggerated in the United States. We did have a civil war, and it killed 600,000 Americans, which is the most lives lost in any American war. I can't think things are so bad in our country that it would come to that. I think this is just, we have excessive political rhetoric, which itself is not unusual in American history. I mean, there's been repeated times where people have said similar things, but it never resulted in a split in our country and actually armed rebellion. I don't really, even Texas is going to stick into the union, isn't it, for a little while longer?
This could be a concern, I think. I do think states will. I think we may see states declining to participate in various kinds of federal initiatives. Now, I don't know if it will come to the point of armed violence, but where states just say, "Yeah, we're not going to do that," or "We're going to do this," or such. We've seen skirmishes of that kind, metaphorically speaking.
And I think the other thing you're seeing, and I agree with John, I don't think civil war is on the offing, but you're seeing people voting with their feet, and they're leaving these crazy states. They're coming to Texas, they're going to Florida, they're going to a lot of the red states, not only for jobs, but for lower taxes, law and order, and things like that. Now, sometimes the worry is that they're bringing their progressive values to those states, and they're going to change those states fundamentally. But what we've seen in places like Montana and Wyoming and some of these other places, that they sort of settle in and they like that lifestyle. And so I think to the extent you're going to see people migration, you're going to see it for those purposes.
Yeah, I think the other thing, well, I mean, one that will prevent it is, let me back up. I think what's going on in the United States at the moment is that a certain elite within the United States is losing its legitimacy in the eyes of the people. It used to be that, if you went to the Ivy League and you were, working at the New York Times and so on, there was this sense that the kind of coastal elite in LA and in New York and in DC, that these were people who could be trusted by virtue of their position, and they had a soft power that they're losing, and they are becoming increasingly coercive to try to compensate for that. But I think there's a pretty sharp limit to how coercive they can become, just given the Second Amendment and just the sheer amount of weaponry spread across the United States, and given the kind of divided loyalties of the military and so on. So I think, but I don't think it's so much one state versus another as a kind of, it's more like the Roman conflict of the orders, where you have a sort of patrician class and like a populist or plebeian class, which is much, much more numerous.
Okay.
I think that goes too far.
Okay.
Well, I like guns. I have guns. I have a lot of guns, but I'm not going to shoot other Americans I'll shoot someone who breaks into my house, yeah. But like for political reasons, I think that's, actually, I want to say, what Cully describes is what we have that maybe Hungary doesn't have, or European countries generally. We have federalism, which is a safety valve. If you get pissed off about the way things are, you can move to Texas, buy guns, shoot yourself in the foot because you don't know how to use the gun properly, like because you're from California, whatever. But I can't imagine Americans actually using weapons on each other because they disagree with federal policy. I think that's... I think that goes too far. I don't really see that happening.
I suppose what I mean is I think it puts a conceptual limit on the willingness and ability of elites to impose things on the populace.
I don't know. The thing I think about is after Brown versus Board. So you had a state. You had a state, actually. This is the farthest, I think, in remote history this happened. You had a state that opposed desegregation, and the governor mobilized the state militia, the armed state militia, to block black students from entering schools. And then President Eisenhower took over the state militia and made them federal officers, and they desegregated the school. That's it. That's much worse than anything we've seen in our time. And I don't think that's going to happen again. I can't see Governor Abbott mobilizing the Texas National Guard and actually blocking federal troops from guarding the border, or not guarding the border.
Well, thank you all. Thank you to this panel. Fantastic. I'd like also just to briefly thank our co-organizers, Danube and the Center for Fundamental Rights. I also want to recognize Gergely Dobozi, who did so much heavy lifting on behalf of this conference. So see you all tomorrow for some more exciting discussions on the rule of law.